this wasn't available before. This was secret or sealed on the docket, and it was only a few days ago that this was unsealed. This hasn't been decided yet. The judge has been sitting on this for what, like 4 or 5 months now? So what we've set up here then is the three of us, Joe, Tyson, Tactical Bra, and me, your host, Leonard French, are going to read this in parts. So you got an order that probably should not have been entered because it was outside the jurisdiction of the magistrate judge to do so. I can just vacate it because it was beyond jurisdiction, and that frankly seems like a waste.
Your Honor, the subpoena isn't about copyright infringement. It's an effort to find out who our client is. We know that because Watchtower does not have any cognizable copyright claim.
I don't know why I can't say this properly. Dark Spilver. So they still want it. They still want the identity, even though everything's taken down. I'm still firmly on the side that they do not want this for copyright enforcement purposes. They want the identity for religious enforcement purposes.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
So the subpoena for the identity was granted, lawyer's eyes only, and then the Electronic Frontier Foundation filed a motion for reconsideration. I don't believe that they called it a motion for reconsideration, but it's basically a motion for the judge to reconsider something that they have already ruled on. The judge made a decision, and then the party is going to point out, wait, judge, you made a decision that's inconsistent with something either you said or the law says, and we want you to reconsider. It's kind of like an instant appeal back to the same judge, and it's allowed for certain things, like basically a genuine mistake. The example that I told was the one time that I got a motion for reconsideration granted. A judge had granted our settlement of a matter, and my client was supposed to get 2 times profits or something like that, and the judge put 1 times profits. So that was a real simple one. Why would you don't have to appeal that all the way to like the appeals court or something, pay an appeals fee. No, you just real quick file a motion. Hey judge, it was supposed to be 2 times, not 1 time. In informal language, like in respectable formal language, and then it was granted. So this is that. They are asking for the judge not to grant the subpoena, and they're on like the second try. They've already lost, and they're trying to get the judge. They're saying, hey, judge, there was something wrong with your decision. And I believe in this one, even they said that even the judge did get something. The judge said something that was inconsistent with the judge's own ruling. So we're going to look at what that might be, what the EFF will bring up here in the proceedings. Now, this is the first time that we have any sort of transcript of these proceedings. This wasn't available before. This was secret or sealed on the docket, and it was only a few days ago that this was unsealed, and we can actually see what the transcript or what happened at the oral arguments with the EFF, with Watchtower, and with the judge. So we're going to find out here what the judge is considering, because this hasn't been decided yet. The judge has been sitting on this for what, like 4 or 5 months now. So it was sometime in April that the original matter happened. Then the subpoena was granted in like the end of April or the beginning of May. And then I think this happened sometime shortly thereafter that. And we've been waiting ever since then to find out whether the judge will grant the motion for reconsideration and revoke the grant of the subpoena, or will the judge not grant the motion for reconsideration and everything is as it is, and lawyer's eyes only get the Dark Spilver identity. So what we've set up here then is the three of us, Joe, Tyson, Tactical Bra, and me, your host, Leonard French, are going to read this in parts. There's 3 parts here. There's Paul DePolidoro, who will be played by Joe Tyson. Is that Joe, you're going to play Paul?
Yeah, sorry. Correct.
Okay, so Joe's going to play Paul DePolidoro, who is the representative, the lawyer for Watchtower for Jehovah's Witnesses. And Tactical Bra is going to play the Alexandra Moss, the representative for the EFF, and for Dark Spilver, for the Redditor, whose identity has been subpoenaed. And I'm going to be playing the court, who is the Honorable James Donato, whom I have no idea why it's before him and not Judge Kim, but we'll figure that out along the way. So I'm going to wear this chicken hat instead of a judge's wig, and you'll just have to deal with that, and I hope that'll be okay. Now, see, this is a weird one. Petitioner is the original petition, right? So the original petition, that's why this sounds weird. We're here on the EFF's motion for reconsideration, but its petitioner is Paul de Polidoro. So when you see petitioner, they're referring to Watchtower and Jehovah's Witnesses and Paul de Polidoro. When you see the movement, that is Alexandra Moss, the Electronic Frontier Foundation, Dark Spilver, and Reddit, basically. And I believe Reddit joined this. I'm not exactly sure to what effect. Like, they just filed "We Join," and that's it. And that was filed by Joe Gratz, who is a well-respected intellectual property attorney, whom I know professionally. So I don't know what the effect of that was. Just like, by the way, we join. Like, that's just it. Okay, great. So without further ado, the clerk calls miscellaneous. I'll do the narrator. Calling miscellaneous case number 1980,005 SK in re DMCA subpoena to Reddit counsel. Please state your appearances for the record.
This is Alex Moss from the Electronic Frontier Foundation, and with me is David Green from the Electronic Frontier Foundation.
Paul D. Poldero representing Watchtower. Good morning.
Good morning, says the court. Well, I just have a couple of questions. Let me start with what I want to understand procedurally where things are, all right? Now, looks to me, Ms. Moss, like you agree. Both of you agree that this was a dispositive order in the sense that it was one and done with the magistrate judge. This is the whole issue presented to the court, and the order resolved it, and that makes it dispositive. Is that something you agree with?
We do agree that the order was dispositive.
Mr. Polidoro?
Your Honor, it's dispositive in the sense that it's resolved the issue of the subpoena itself. However, Judge Kim has retained jurisdiction as we move forward.
Well, for any production disputes.
That's correct.
No, I understand that. Just sort of you would agree on the substantive issue, the main game, that was dispositive.
Yes, Your Honor.
May I just correct one statement? Judge Kim in the transcript specifically made clear that she couldn't reserve jurisdiction because even if she did, the Supreme Court would have the opportunity to change that. So she didn't rule on jurisdiction or offer to continue having jurisdiction over any discovery issues. That's
okay. I understand. We don't have to worry about that right now. It may come up later, but we don't have to do that right now. Now, typically, a motion for a subpoena would not be considered dispositive because it doesn't decide the merits of the case. But I think there actually is good reason here to agree with you that it is a dispositive issue in this sense. There is no main case where the subpoena was served in aid of discovery. So in that case, typically these motions to compel or motions to quash come in because there's some substantive litigation going somewhere, and there's something in the district somebody wants, and there's a fight about it. Obviously, the fight about that has no impact on the merits of the case, so that's clearly non-dispositive. Do you see what I'm saying, Ms. Moss?
I do. I agree with Your Honor.
Mr. Polidoro?
Yes, Your Honor.
And there is a group of subpoenas that are called agency subpoenas, like those from the NLRB or FTC and other places, that are very analytically similar to what happened here. There's no case, there's no main litigation going on, but the agency serves a subpoena. And typically, at least in our circuit, those have been held to be dispositive. So I'm just telling you where I am. And I think that's how I'm going to come out and see it your way on that it is dispositive, okay? Now, the second step is what happened in front of the magistrate with consent. Now, Mr. Polidoro, you and your client clearly consented because you filed that form saying, I agree to have the magistrate judge handle this. Now, the EFF and your client, what was his name? Do they call him Dark
Spilver is their Reddit name.
Yes. Say that again?
Dark Spilver.
Dark Spilver. Okay. EFF and Dark Spilver didn't file that form, and did you consent to the magistrate's jurisdiction?
No, Your Honor, we didn't consent. And we didn't have any notice that the magistrate considered this the kind of proceeding that would be proper to treat under Section 636C. For the reasons, as you've discussed, that we viewed this as a dispositive motion, We believe it should be treated like other dispositive motions, like a motion to dismiss, and therefore isn't eligible for treatment under subsection C. But even if it were, there was no notice and no opportunity to provide consent to give up having an Article 3 judge consider us in the first instance.
Well, you got the form, that same form that Mr. Polidoro got, because the clerk's office mails that out to all the participants as soon as you get assigned to a magistrate judge. Did you get that form, the consent and declination form?
To be honest, Your Honor, I don't recall receiving it. And that, of course, might be my error, but no.
Well, it comes out in the packet you get from the clerk's office. I mean, Mr. Polidoro, that's how you got it, right?
Correct, Your Honor.
It goes to all the litigants, so I'm going to assume for a minute that you did, just as a talking point. But then you certainly saw on the docket, you certainly saw that Mr. Polidoro and his client filed the notice of consent. I mean, you saw one side doing it. It's right on your docket that you have ECF access to. Look, I'm just trying to figure out what happened. So you never said to the magistrate judge, we consent or we decline. It just never came up on your side?
Correct. We didn't believe that this was the kind of proceeding where that would be necessary. We viewed this as a dispositive argument, so we didn't provide explicit consent. We also didn't receive any notice that Judge Kim viewed this as a proceeding that would be treated under 636C. So when we participated in the proceeding, we didn't have any notice or reason to believe that it was being treated that way.
Even so, why didn't you just take a stand? Why did you just say nothing?
In retrospect, you're right. Next time, that's what we should have done to avoid this. And frankly, we were, I think it's a point that would be for next time.
So it just sort of happened, in other words. Okay. And you all didn't have a conversation with the magistrate judge about consent?
Correct.
Is that true, Mr. Polidoro?
That's true, Your Honor. However, I do believe Judge Kim has standing orders with respect to consent.
I think that's true. I think you cited those in your papers, just in
Yes, Your Honor.
the back and forth in court that never came up. Ms. Moss?
No, it never came up.
I didn't see it, but I just wanted to make sure I have everything. Did you all have a discussion about whether this motion to quash would be considered dispositive or non-dispositive?
No, we didn't have any conferences prior to the hearing.
But even at the hearing, you all didn't talk about that with Judge Kim?
We've had no conversations about it with Judge Kim or with opposing counsel.
Is that right, Mr. Polidoro? Well, it's a procedural twist, in my view, and I'm just going to tell you where I'm leaning. I'm going to do a short written order on this just for clarity because I find it to be an interesting issue. If we start from the premise that this was dispositive, the magistrate judge had authority to issue an order, a footnote order. I'm going to come back to that in a minute, but the magistrate judge would have had authority to issue an order only with the express consent of both sides. If both sides don't consent, the magistrate judge cannot resolve a dispositive matter. This is an unusual twist. I'm not faulting anyone because motions to quash typically aren't dispositive, but in this setting, as I said, and we all agree a good argument can be made that they are, this one was dispositive not only because of the DMCA section 512H, but because of the main analogs and some other things I'll put in the order. So you got an order that probably should not have been entered because it was outside the jurisdiction of the magistrate judge to do so. Now that's fine. The reason I footnoted order is I have sort of two options here. I can just vacate it because it was beyond jurisdiction, and that frankly seems like a waste. You all spent time and money on these briefs, and everything is teed up. Or I can treat it as a report and recommendation, which is typically what we do when a magistrate deals with a dispositive matter without consent. Sometimes it's referred by a district judge, sometimes it just comes up through the case system we have, but it's considered a report and recommendation, not an order, which seems like a technical difference, but it's not a technical distinction, it's actually a substantive distinction. So I'm inclined to do that and save you all from having to go back to ground zero and redo everything, just move on from there. How does that sound, Ms. Moss?
That sounds good to us.
Are you okay with that, Mr. Polidoro?
In a sense, Your Honor, we still feel that under Roll and this circuit's decision in Henderson that the appropriate step would have been a direct appeal to the Ninth Circuit.
Actually, I'm glad you mentioned that. On the issue of implied consent, I spent a long time. So, Roel, of course, is the Supreme Court case on implied consent. I spent a lot of time thinking about that and reading what I could read that I thought was applicable. Here's what I've concluded. I was going to address this in the order, but I'll just tell you what I'm thinking. So, you can, of course, have implied consent to a magistrate judge's treatment of a dispositive issue. And the problem that I have with Roel is the magistrate judge asked constantly whether anybody had declined her authority or whether anybody had any objection to going forward. And on that record, Justice Sutter said, well, if you're asked that many times and stand there like a stuffed straw dummy, that's on you. You can't say later that you didn't consent. You didn't have that here. That just never came up. So there was no dialogue at all with the magistrate judge, either about the dispositive or non-dispositive nature of your motion to quash or consent or declination. Nothing happened. So in Roel, Justice Souter made it pretty clear that it was the repeated questioning that turned the trick. Now, even so, I was willing to think, well, EFF filed briefs and had an argument. Why isn't that enough? And somewhat to my surprise, I found a Ninth Circuit opinion, Allen v. Meyer. Do you know it?
No, sir.
Allen v. Meyer, 755 F. 3rd, 866. It's from 2014. It's a good 11 years after Roel, and in that case, the same issue came up. Magistrate judge ruled on some motions to dismiss, and it was a civil rights case against some police officers, and the police officers themselves brought motions to dismiss and brief them, and then afterwards, there is some dispute about whether they had consented to the magistrate judge. And to my surprise, the circuit said on that record, which is almost identical to the record here, quote, "It is undisputed that the officers furnished neither express nor implied consent to jurisdiction before a magistrate judge," closed quote. That's Allen. So, in other words, the circuit has expressly declared, apparently, that simply submitting briefs and appearing in arguments is just not enough, and I cannot see a way around what Allen v. Meyer says. So I'm not sure it's the right answer, but it is the answer on the table. I think that's what we have. Otherwise, I might have been inclined to think that there was a pretty good argument under just common sense, if nothing else. And if you go to a party and if you drink the punch, you can't say you weren't a guest. But anyway, that's how I think it's going to roll out, okay? Having said all that, I'm just going to do it on a R&R, reports and recommendation basis, okay? And what would you like to say about the merits?
Your Honor, the subpoena isn't about copyright infringement. It's an effort to find out who our client is. We know that because Watchtower does not have any cognizable copyright claim. It also doesn't have any actual need to know our client's name. All it has submitted here are bare assertions that it owns material that Judge Kim found was overwhelmingly fair use. Now, based on this, Your Honor, there is no basis for a compelling disclosure of our client's name under Highfields, both because the underlying claim has no merit and because the balance of harm tips overwhelmingly in our client's favor, particularly given Watchtower's failure to demonstrate any actual or likely harm would result if its request were denied. We think the real danger here is the slippery slope that ruling for Watchtower would create. They're asking for a rule that lets anonymous speakers be unmasked, even when there is overwhelming indicia of fair use, without any consideration of whether that's fair use. That will guarantee that some anonymous fair use commentary is quashed. That will turn the DMCA into a tool for powerful organizations to silence speech that they don't like. And that's what's happening here.
Your client lives overseas, is that right?
Our client is not a citizen or resident of the US and is overseas, correct?
Okay. And what's your understanding of the purpose of a Section 512H subpoena?
Is to uncover the identity of somebody suspected of copyright infringement or to facilitate infringement litigation or other specifically copyright enforcement.
All right. Mr. Polidoro?
Yes, Your Honor. Taking a step back to put this in context, Judge, at one time, Watchtower was a publisher of religious literature, and Watchtower zealously litigated freedom of speech, freedom of press, and freedom of religion. Virtually overnight, Watchtower turned into a digital media entity where the majority of publications are now digital. We also have our jw.org, which is our website. It's the primary means of disseminating religious and spiritual food. Watchtower saw that it was the wild, wild west with respect to copyright infringement. So they started to give some legal attention to the infringements that were taking place. What we've done is we've identified some cases that we're going to pursue. That's our next step, is actually pursuing copyright infringement cases. Now, let's speak about this specific case. In their reply, counsel says that there's two items here. Your Honor, there's an article that speaks about Bible-based principles in donating, and
That's the back page, right? The copy I got?
they refer to it as the back page, Your Honor, but it's a standalone article on jw.org.
It's a standalone?
It is. It's a standalone article on jw.org. And even as a standalone article, it receives copyright protection. It's a scripturally based discussion of why it's appropriate under the Bible to donate. And then there's the chart. In their reply, counsel says that the chart is not copyrightable. There's only one way to answer that, Judge. So, what we've done is we filed with the Copyright Office for expedited registration, and that came in on Monday, Judge. What I'd like to do is provide you, Your Honor,
Yes, please.
and counsel with a copy of the certificate of registration. It's certificate number TX8747858, and that is as to the chart.
This is for that.
That's for the chart discussing data protection.
Okay.
Now, there was also apparently, despite Judge Kim's finding, that Dark Spilver did not contest registration and thus ownership, and that's on page 10. Counsel, in their reply, still seems to have an issue with whether Watchtower actually owns the copyright on this article that was in the Watchtower and on jw.org. So I would like to hand up to the court certificate of registration for the article, and that's TX8614505. And I'm providing counsel with a copy of that also.
Okay.
Your Honor, from a purely statutory perspective, the DMCA allows a copyright holder to use the subpoena process to advance their copyright protections and to identify an individual who has infringed. This case, Judge, has nothing to do with anonymous speech. An internet user can say whatever they choose to say anonymously on the internet. They're entitled to do that. What they're not entitled to do is to anonymously infringe on someone's copyright. Now, we believe the appropriate test in the Ninth Circuit was a test articulated by the Ninth Circuit in the Lenz case. Lenz speaks about fair use, and what the Lenz court said is the copyright holder needs only form a subjective, good faith belief that a use is not authorized. Watchtower does, in every subpoena, that subjective good faith analysis.
Let me just jump in. I want to make sure I understand that chart. So that chart was a document that Watchtower put together. Is that right?
That's correct.
So this is just straight out of a Watchtower.
No, that's something that we prepared for internal use, Your Honor.
I understand, but it's straight out of the Watchtower files.
Incorrect.
It's not something that Dark
Spilver
put together.
No, that's ours.
All right.
Although, if I may, there were modifications. The chart that Dark Spilver actually posted was altered from the original version created.
I'm looking at it. Can you show me where those might be?
Well, if you're looking at both, the sort of layout was reformatted. The content wasn't altered, just the visual appearance, so that it could be more easily viewed on a computer screen.
All right. So he just fiddled with the formatting.
Yeah, I think it was originally an Excel file, and then it was turned into a flat image that could be viewed.
I see. Okay. But the little boxes of information were not altered.
The content's correct.
Okay. All right. Go ahead.
Thank you, Your Honor. As for the article, Your Honor is correct for the chart. The chart, I think he just published with a caption and with the word leak. That was it. The chart is in its entirety. And the article on donations, again, republished in its entirety under the caption, guess what? So the Lenz court, I believe, sets the standard for what a copyright holder needs to do. And we do that in every case, Your Honor. The legal team, myself personally, take a look at the infringements that we're considering making the subject of the subpoena. I have a forensic team that works with me. In this instance, I looked at the universe of what Dark Spilver had posted. Some we made subject to the subpoena. Some I've decided was borderline fair use, and we decided not to pursue that.
Can you give me an example of what you thought was fair use that you wouldn't pursue?
I think it was something more commentary based, where he didn't use our whole entire article. This just veered entirely outside with respect to the taking of the article in its entirety, and virtually nothing transformative in nature. Some other articles may have been slightly transformative. There's nothing transformative about what he's done in this case. So under DMCA...
I'm sorry to interrupt. So your position is, as far as your client is concerned, Dark Spilver is perfectly free to criticize the church all day, every day, for being avaricious and greedy, his words, not mine, but you draw the line when he starts using your own copyrighted material as part of that.
Precisely. And Dark Spilver has done that, Judge, and many do that on the internet. We're not the internet police. It's clear individuals have a right of anonymous free speech, but it's their own free speech. If we look at the cases that set the right for anonymous discourse in the United States, Watchtower versus Stratton was based on McIntyre, and it was Mrs. McIntyre who was going door to door giving out pamphlets addressing some sort of upcoming election, I believe. It's her own speech. She didn't steal someone else's speech and say, I have a right to anonymously steal this and post it. The Arc spillover can say whatever he wants from his own mouth. He just can't violate other individuals' copyrights.
Wouldn't you agree, though, that really the issue here is whether the use of the copyrighted materials would be fairly characterized as fair use or not?
You know, Your Honor, we think that's premature as an assessment. We think that under the DMCA statute, Congress has already made this assessment with respect to fair use and free speech. Congress has set up that if someone feels that they did not infringe, they have the right to file a counter notification under the statute. Or if they feel that there's a misrepresentation on the part of Watchtower, they have a 512H remedy. The fair use analysis that we're now shoved into prematurely, we're almost at like a trial stage to prove or disprove this, is because of the application of high fields and art of living and signature management. May I speak about that for a moment?
Please, yes.
The Highfields case we think is inappropriate to apply in this setting. First, Highfields was not a DMCA case. Highfields involved an individual who posted under the name Highfields, and the corporate entity, I think it was a financial concern, had some challenge with that. And it appeared that they were casting about and thrashing about for some cause of action. That's something fundamentally different here, Your Honor. We have a cause of action. It's copyright infringement. So the policy of Highfields.
Highfields is just a Rule 45 subpoena.
That's correct. It doesn't even apply to this process. But under Art of Living and Signature Management, they've engrafted the Highfields analysis into the DMCA process, it seems. But there's a difference in both of these cases that are absent here, Your Honor. In the Art of Living, there was an internet posting of the name of the dissident and his contact information. And there appeared in that case that there was a discussion of a threat of physical harm. And that's something that's very different indeed. And that's also the case in Signature Management. If we look at it, it's at page, I believe, 1149, footnote 5. The court noticed the language on the internet that was harassment that elevated to the form of a threat. So those two cases were fundamentally different indeed. Even in Highfields, it underscores the need why a copyright holder needs to know who this person is. It's not only to sue them. Because I think even in Highfields, it said regardless of counsel's assertion that they would accept service of process, there's more infringement litigation. There's the opportunity to have a pretrial deposition, to actually see someone face to face and move forward with the case. Watchtower, as the copyright holder, also has the right to seek permanent injunction against Dark Spillover for the violation of his copyrights. I don't know how that would get enforced, Your Honor.
I appreciate it. Let me ask you this, though. Lentz is not. How are you going to manage Lentz?
I think Lentz, there was a discussion of what's the role of fair use in this whole process. And what Lentz said is it's subjective, good faith belief that the copyright holder needs to do something, just not nothing willy-nilly sending subpoenas out all over. And Watchtower complied with the Ninth Circuit requirement. I've done the analysis. My associate has done the analysis. Our forensic team works with us. So we've had a subjective, good faith belief that the use was not authorized. So
Well, just on that issue, I think that's a reasonable reading of Lentz because Lentz clearly says it's the copyright holder that must consider the possibility of a fair use issue, which I think is at odds with how you describe what Congress did. I don't think Congress has made that balance, and I think Lentz pretty clearly says the burden is on the holder. Otherwise, Lentz would have said what you said 5 minutes ago. We don't have to address this issue because Congress has already struck the balance. Do you see what I'm saying?
yes, I do, Judge.
Do you agree with that?
I think so. I think Lens has gone beyond with respect to fair use. But having said that, Your Honor, I think Watchtower complied with it.
All right. Let me just pause there and hear from Ms. Moss.
Of course, Lens is a suit about wrongful takedown. This is Watchtower's effort to enforce a subpoena. The fact that copyright holders have to consider fair use before even sending a takedown notice confirms that courts have to consider fair use before enforcing the DMCA. My friend's effort to rely on Lens completely ignores the procedural context of that case and of this one. I also want to turn to the point about the difference between speaking anonymously about one's words and somebody else's, right? This is where my friend's argument is really driving at the core of the fair use doctrine. The whole point of the fair use doctrine is to allow people to use other people's copyrighted works for purposes of criticism and commentary without getting consent from the copyright holder.
Just on that issue, the whole work? Why not just a couple of lines from the work?
Well, the fair use...
Why just take the entire article untransformed and just put it up? You know, copyrighted material. I mean, I certainly think it's fair to comment on it, have quotes from it. I don't think there's any doubt that that would be, in this context, fair use. But when you wholesale, I'm just asking, I don't know what the answer is, but when you take a wholesale document and just throw it up, I mean, how is that fair use?
If our client had taken the whole Watchtower magazine and put it up on a link downloadable, as you saw in the signature management case, we might be having a very different conversation. Our client took one page, the back page. As Judge Kim said, this is a small portion of the 32-page work. The registration that they've given you shows that what's registered is the entire magazine. So, whatever may or may not be a standalone link on jw.org, what's registered is an entire volume of which the portion our client used was 1/32.
So your colleague has said that, in fact, is not right. It's a freestanding, you said it was a freestanding article.
On the website, you're absolutely correct, Judge.
I would be interested if there was any registration for that freestanding article or whether the registration was for the whole magazine.
Well, the registration I have is for the volume, not the individual page. Is that right?
That's correct, Judge.
Okay, so there's no separate copyright just for the one article.
No, we wouldn't copyright every page. Your Honor, I believe the Ninth Circuit has already addressed this point that counsel is making about the one page out of the 32-page magazine. If I can turn Your Honor's attention to the Hustler magazine versus Moral Majority, the site is 796 F 2nd 1148, and this quote will be from page 1155. It's a Ninth Circuit decision, 1986, and I quote, "A creative work does not deserve less copyright protection just because it is part of a composite work. Therefore, in this case, we view the defendants as having copied an entire work. In that instance, the defendant copied one page from a 154-page magazine. So we believe that the Ninth Circuit has already spoken to the issue that counsel is raising." Monge versus Maya Magazines. And this site, Your Honor, is 688 F 3rd 1164. Again, it's a Ninth Circuit decision, 2012. It speaks of the question Your Honor had posited. Here in the Monge case, and I believe it's on page 1174, the evidence reveals that generally exact copies of whole or substantial portions of an article are posted. There is little transformative about copying the entirety of or large portions of work verbatim. And I misspoke, Your Honor. That's LA Times versus Free Republic. That site is at page 24. Now,
Okay, let me hear the rest.
May I respond?
Please, yes, go ahead.
I'd like to turn the court to what Judge Kim said. The advertisement, that back page, whichever you prefer to call it, was largely informational and functional, directing readers how to make donations online. Your Honor, if you take a look at that back page, there's very little creative content to it. In fact, the quote-unquote article consists largely of biblical quotes that, of course, Watchtower couldn't have written itself. In fact, looking at the back page, it's not a creative work of the kind at issue in the cases counsel has cited. It's a functional and informational back page that primarily focuses on instructions for how to make online donations. Our client could not have used any less than the whole back page because the whole point was to show that Watchtower was using the entire back page to solicit and instruct people on how to make online donations. For our client, this was an important point because in the past, the same section would have been devoted entirely to an article that wouldn't have included a request for online donations. They also believe that the practice of emphasizing online donations at all is in contrast with church practices as opposed to, for example, encouraging or focusing on non-monetary contributions or contributions to a local congregation. Our client's point was really to show, look what they've been using the back page for, and look how much of it is being used. And that was the point of their comment, saying, what gift can you give Jehovah? Guess what? And it was to comment sarcastically and suggest to others that they should think critically on what was happening on that back page. And in case after case, the question isn't whether it's one page or all of it. It's whether any less would have served the transformational purpose. And here, they just couldn't have used less.
Okay, that was very helpful. Let me ask two closing questions.
Your Honor, may I impose the court just to briefly respond to that?
Very briefly.
Religion is protected. Religious discourse under the Worldwide Church of God versus Philadelphia, Church of God, a Ninth Circuit case, 227 F 3rd 1118, says that scriptural discussion is precisely the type of creativity that the Copyright Act was intended to protect. Harper versus Rowe says that there's not a free license to reproduce whatever you want. And what Judge Kim said is that Dark Spilver reproduced it to evoke conversation. The Supreme Court has already ruled on this and said there's no warrant for judicially imposing a compulsory license.
Did you send a takedown notice to Reddit?
Yes.
Did they take it down?
Yes. They took down the ad. They did not take down the chart.
If I may intervene, our client took the chart down.
So the chart is off. So your client took the chart down and Reddit took the ad down. I mean, Mr. Polidoro, let's just talk practically here for a moment. The poster is outside the territory of the United States. I mean, it's off the web now. It seems that the church's main concerns have been addressed by the takedown, and I wasn't opposed. I don't know why I can't say this properly. Dark Spilver.
Dark Spilver, yes.
Dark Spilver has cooperated and voluntarily took it down. Isn't it enough to call it a day and not necessarily find out who he is or she is?
I think Watchtower, as the holder of intellectual property, has the right to move forward with copyright litigation where appropriate.
That person doesn't live in the United States, so what are you going to do?
We're accepting that as a statement of fact, but for this purpose, Your Honor, just because he doesn't live in the United States doesn't mean we can't bring actions against him wherever he is.
You're not going to bring it under U.S. law. You're going to have to sue under the law of a foreign jurisdiction.
That's the whole purpose of the statute, Your Honor. Allow a copyright holder to gather information to make those decisions. And my client would like to make those decisions.
Injunctive relief is moot because the article has been removed. So you're looking at damages. What are they? Statutory damages?
Statutory damages for the article on donations, but also Watchtower's right to pursue a permanent injunction. They have their array of statutory rights as a copyright holder.
Permanent injunction overseas would impose serious extraterritoriality questions.
Well, it wouldn't be a U.S. injunction. Don't know what you would get. Who knows where this person lives? I'm just, agreeing that the person is not within the territorial boundaries of the United States.
We also have a bigger picture, Your Honor, which is protecting JW.org.
I understand, and that's perfectly legitimate, and that's what the notification and takedown process is for. You've achieved total victory with that. I'm not sure what total victory plus really means, but it's your case, not mine, so I will decide the issue and I will have it out shortly.
Thank you, Your Honor.
Shortly in district court terms, all right?
Thank you.
Thank you.
And of course, shortly is now it's 3 months later and we still don't have anything. That was August 21st or August 19th.
It was August 1st that it was argued.
Okay, August 1st it was argued.
Yeah, so August, September, October,
there you go.
Almost end of November. That's 4 months. Yep.
Yep.
So maybe soon?
Maybe. District court terms. I like that. Let's go back to that. Back here. Shortly in district court terms. All right. Yep.
I just have one thing to say about the Hustlers case. And whether one page can be copyright infringement if the whole package was really big. So I actually read the case because I'm a nerd and I'm crazy. At the core issue was whether the Hustlers comic, so there was a comic that was in it, and I believe it was Jerry Falwell or someone like that, had copied the comic and then sent it out in his donation request packages. So he had sent it to people and said, look at how they're attacking me.
Yeah.
And then Hustlers sued him for copyright infringement for reproducing their work. Because people pay good money to see those comics.
Yes.
And the court actually ruled that it was fair use for him to do it because there was, I guess there was an educational component, or there was they were changing the meaning of the comic.
Yeah.
So the comic was now not meaning to make fun of Jerry
you weren't
Falwell.
going to Jerry Falwell to see the comic, so he wasn't market usurping either.
Yes. So they ruled that yes, the one page could be copyrighted. And yes, the one page was, that copying that one page was substantial enough because comics were an essential heart of the matter sort of thing. It was, when you talk about music, how the hook is kind of like that's the
heart of the matter. Yeah.
Yeah. So that comic was sort of at the heart, the core, the thing that you buy the magazine for. Now, other cases that were cited in that case talked about how the front page of magazines and the back pages of magazines don't have quite the same
Right.
protection
Because they're
because
visible to the public from the newsstand.
yes. And so they're visible to the public and they aren't the heart of the magazine, and it's
Yeah.
typically not why you buy the
And
magazine.
let's remember that the Jehovah's Witness Watchtower magazine or whatever is basically half an advertisement for their religion. Of course, they consider it religious beliefs and everything, but come on, let's be clear. It's marketing material for joining a religious organization. And that's what it is. It's an advertisement. I'm not getting down on it. Religious people have to advertise too. That's how it works.
We call it proselytizing.
Proselytizing, right.
Proselytizing, yeah.
So, spreading the good word.
This whole thing just
They have
stinks
to advertise.
Yeah, so they still want it. They still want the identity, even though everything's taken down. I'm still firmly on the side that they do not want this for copyright enforcement purposes. They want the identity for religious enforcement purposes.
I mean, the judge was trying to fish a little bit there to figure out, okay, so what exactly are you going to do? I
Yeah,
mean, with this, I mean, what would be the damages? What would be the statutory damages in this thing?
yeah. I would need to see that registration because there's strict requirements for statutory damages as well. So that
Yeah.
magazine has to have been registered timely.
Yeah, so it has to be registered before the copyright infringement took place or within 3 months of publication, if I remember correctly.
Possibly within 30 days of the infringement too.
Possibly
I'm not sure
30
if that's
days?
might be within 30 days of publication though. I have to read through 17 USC 504, I think.
Would it
is.
matter if there are no statutory damages? I mean, if that
Well,
were
statutory
admitted here
damages
somehow.
are damages set by law. So
Yeah.
do you mean to say that, or do you mean to say actual damages? Like, what is that? What happened? There is no actual damage here. For example,
Well,
I
the
believe
judge
there's
is
no
asking.
actual
Well, the judge is
damage.
asking. You want to see for statutory damages, and I believe their side is the JW side is trying to say, oh well, we might we might seek statutory damages in that country or whatever.
Yeah.
Does it matter if there are no statutory damages whatsoever?
Oh, yeah,
that
that's
could be
true.
pursued
There
in the
might not
US?
be statutory damages in that country because that's not a Berne Convention copyright regime.
So if it's actual damages,
Yeah.
like posting something on Reddit, I mean, really the damages
just
would be
further
diverting. Yeah, it would be diverting web traffic away from jw.org.
That's not
because,
damage.
Yeah.
It just further betrays their underlying motive. This is a pretense to get the identity of a person who has violated the religious code of a religious institution, and that's not what copyright was meant to be used for. But it really depends on if this judge sees it for what it is, or if this judge tries to strictly apply the law. Because judges aren't supposed to try and go outside of the matter and figure out what's really going on. They're supposed to figure out what's going on from the record. And fortunately, all those arguments are on the record thanks to the Electronic Frontier Foundation, but still, that puts the judge in a really weird place. If there were no religious implications, if there were no religious consequences or no extra consequences to Dark Spilver, it would be, I think, a little bit easier to argue one way or the other. And I honestly don't think that you see this very often because other organizations don't do this. They don't go after people's identities using extremely thin and tenuous copyright allegations. It does happen. And when it does, we should shine our giant flashlight on it because it needs to be exposed. But we don't see it that often. The times that it's used, it's pretty much used legitimately. There was actual infringement. It's really clear that it was infringement. It's per se copying of an exact file, like they were saying in the example case, and not this weird intersection of religious code and copyright law and commentary. So I think the Hustler case says exactly the opposite of what Polidoro cited it for. But we'll let the judge figure that out. Why the judge is sitting on it for 4 months, I don't know. Maybe the judge is waiting to see if it just goes away. Sometimes they do that. Wait to see if the whole thing is just moot now and they have a follow-up later and maybe there's just no reason to proceed forward. Or maybe it is just taking 6 months in district court time, which sometimes these things do. It's not important to the judge, so every time something more important comes up, this thing gets put to the back burner. That's very possible too.
What I find interesting procedurally, which I'm a nerd, I don't know if anyone else is going to find this interesting, but the Lens v. Universal case said you have to make a subjective evaluation of whether or not it's fair use before you do the takedown. And they said, yes, Jehovah's Witnesses have done that analysis and they do not believe that it is fair use, therefore we're proceeding. But then Judge Kim talked at length about how this is likely fair use, about how there was, very little damage. It was only a portion that was used. It was used for the purpose of commentary.
Very little, if any, market usurpation.
Yeah, that it was
transformative in purpose. It was not being posted on Reddit to elicit donations. It was being posted to criticize the organization. Very, 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 very close to a fair use already without any further analysis.
And so I'm wondering, I know that there's no rule that you can't, keep pursuing your subpoena after you've already had a judge tell you you're probably wrong in your fair use analysis.
Yeah.
But I think it's, in my mind, interesting. I almost want there to be a rule that now that you've had a judge do a superficial kind of primary analysis and says, this looks pretty fair use, that they can still pursue, because before they talked to the judge, they made their subjective evaluation. So they don't have to change their mind after being told.
Yeah. And it is true that the misrepresentation standard is having formed a subjective good faith belief, but that also is a legal proof you get to do. You get to go to court and testify about what steps you took to form the subjective good faith belief. And if you did not actually sincerely take those steps, then the court will rule against you, and it is considered a misrepresentation. But we're not here on the misrepresentation. We're here on the opposite standard, which is whether they get the subpoena, the 512H subpoena for Dark Spilver's identity. And so that was really interesting to me. I really enjoyed reading through that, and I'm looking forward to the judge's ruling whenever it comes. And we'll definitely report that to you at the moment that it drops. We'll probably go live and go over it, because this is amazing to see a religious organization subpoena a Reddit poster and try to get their identity uncovered so that the organization can pursue extrajudicial consequences. I mean, that's what I anticipate is happening here, is that they want to punish them in the religious sense. Or I think they called it re-education, which is just a great word for it. That's just a great word for it. Forced re-education.
Yeah, your relationship with God has been fractured by your criticism of the church. Therefore, you must go into intensive therapy to repair your relationship.
Yeah, so this is not
until
God.
You stop exhibiting the symptoms.
Yeah, this is men. This is not God. This is men. Anyway, I'll stop short of any further discussion there. Thank you for watching. That is our show. I am Leonard French, your favorite copyright attorney. This is a community-supported legal education channel. Thank you for your support on patreon.com/ljfrench and sponsus.com/law. Thank you very much to our supporters in the month of November. Thank you to our $50 plus supporters: Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, SnorreW, Blackleaf, Benjamin, Hitov, and Steven. And thank you to the $5 plus supporters who are scrolling in front of me and on the LED panel behind me. We love you all. Thank you for your support. We'll see you in the videos that drop. Have a great Sunday. I'm Leonard French, your favorite copyright attorney. Bye.